New York Racing Fair Mutual Wagering and Breeding Law, Section 102, provides that the New York State Gaming Commission shall consist of 7 members appointed by the governor by and with the advice and consent of the Senate. 4 members having been confirmed by the New York State Senate are necessary to afford the commission an ability to establish quorum and undertake action. This present meeting of the commission is now called to order. Ms. Secretary, will you please call the roll?
Brian O'Dwyer.
Present.
John Crotty. Sylvia Hamer.
Here.
Martin Mack.
Here.
Peter Machete.
Here.
Marissa Shorenstein.
Here.
Jerry Skurnick.
Here. Ms. Secretary, please have the record reflect that a quorum of qualified members is present, thus enabling the transaction of business. Please note that Commissioner Machete is joining us from our Schenectady location. Bilateral visual and oral communication between Schenectady and New York has been established. Mr. Chairman.
Minutes of the commission meeting conducted on 16 March 2026 have been provided to the members in advance. At this time, I'd like to ask the members if there are any edits, corrections, or amendment. Hearing none, please start the record reflect the secretary that the minutes were accepted as read. The next item of business is the report of our executive director, Mr. Williams.
I'd like to provide a brief update regarding a new commission website, the opening of Resorts World Commercial Casino, an update on the state budget, and the pre-proposal comments that we received. First, last week, the commission initiated a micro website on the dangers of unlawful gambling, including prediction markets and offshore operators. Located at ny.gov/riskybet, one word, the website is designed to provide visitors with information about the perils of unlawful gambling and how regulated gambling preserves the integrity and protects players. This site is being marketed and informed through all of the commission's social media accounts. As you are aware, Resorts World New York conducted its grand opening on April 28th, 2026 with 2,429 slot machines and 242 table games. Staff's general impression is that Resorts World experienced and continues to experience general growing pains of a commercial casino opening, underscored by the magnitude of demand. Staff are working with Resorts World to address all concerns. The recent opening, of course, is the first step of Resorts World's articulated goal of investing $5.5 billion to establish a facility with 4,635 slot machines and 534 table games, a 7,000-seat multi-purpose entertainment venue, and a new 1,600-room hotel. While their initial proposed opening date for slot and table expansions was forecast to be on June 29th, they have since apprised staff that the date has been shifted to October 26th. At this time, planned openings of Crockford and the Salon Privé expansions remain scheduled for December 14th of 2026, while the Conservatory casino expansion remains on schedule for January 1st of 2029. My update regarding the fiscal year budget is that I have no update as negotiations continued through the weekend. With respect to items affecting commission operations, nothing has yet been finalized. Finally, I'd like to provide a high-level overview of the comments received in response to the draft regulations proposing safeguards to protect youth and implement additional responsible gaming practices. At commission direction, staff released 2 draft regulations proposing safeguards to protect such, seeking pre-proposal comments through May 15th, 2026. We received 203 comments, with approximately 170 appearing to be the results of coordinated AstroTurf campaigns, both in favor and against aspects of the pre-proposed rules. That said, we did receive quite a number of letters with substantive comments and recommendations. Staff will be reviewing the materials and hopes to have some revisions if deemed necessary for consideration at a future commission meeting. For those interested, we're going to post all the comments received once the personally identifiable information have been redacted. Mr. Chairman.
Thank you. We have rulemaking for adoption and 3 proposals for consideration. One rulemaking for adoption. Mr. Williams.
For commissioner consideration is adoption of rules to add a new Powerball double play game feature and set forth rules for the existing Powerball Power Play game feature in the commission's Powerball rules. The double play game feature, which is currently offered in 27 U.S. jurisdictions, enters a player's Powerball bet ticket numbers into a second drawing for a chance to win additional prizes for an additional price of $1 per play. The double play drawing occurs shortly after each Powerball drawing using the same fields of numbers used for the Powerball drawing. The double play winning prizes range from a share of $10 million first prize to $7 prize. If you recall, when we proposed the Powerball game, staff noted that a Power Play game feature had been offered since 2010 without the play detail customarily found in commission regulations. Thus, staff thought the inclusion of Powerball game feature details into regulations would be appropriate to provide consistency and to promote the ease of reference for players. The commission published a notice of proposed rulemaking in the February 28th, 2026 State Register. Public comment period expired on April 20th. No comments were received. Staff recommends that the commission adopt this rulemaking.
Commissioners, any question on the adoption of both Powerball double play game features and standards for Power Play game feature? Hearing none, may I have a motion to adopt the rule?
So moved.
Second,
Second.
all those in favor?
Aye.
Opposed? Motion carries unanimously. Mr. Williams.
For commission consideration is a proposed rulemaking to one prize level of the new multi-jurisdictional Millionaire for Life lottery draw game. The Multi-State Lottery Association is determined to amend the game rules, providing a liability limit for the second level prizes based on the number of winners in a single drawing, beginning with the drawings on or after September 1st, 2026. Staff recommends that the commission authorize this proposed rulemaking.
Is there any discussion on the rule? Hearing none, may I have a motion to adopt the proposed rule?
So moved.
Second,
Second.
all those in favor?
Aye.
Opposed? Motion carries unanimously. Mr. Williams.
For commissioner consideration is an amendment to correct a Scrivener's error in one of the prize level odds in the Lotto lottery game. As no public comment on this proposed rulemaking is anticipated, staff recommend that the proposal be authorized as a consensus rulemaking.
May I have a motion to propose this rule as a consensus rulemaking?
So
Motion.
moved.
Second,
Second.
all those in favor?
Aye.
Mr. Williams.
Racing is anticipated to return to a redeveloped Belmont Park on September 18th, 2026, with the addition of a racing surface. Present rules provide for surface changes from turf to dirt, but do not contemplate moving from dirt to something different. To accommodate this, staff amended the wagering surface rule or changes rules to accommodate the the wagering consequences of a surface change to a course of any surface. Staff recommends that the commission authorize this proposed rulemaking.
Any discussions on this matter? Hearing none, may I have a motion to propose this?
So moved.
Second,
Second.
all those in favor?
Aye.
Motion carries unanimously. Adjudications, Mr. Williams.
Harness trainer Daniel J. Rawlings was issued a notice of summary suspension and joint hearing on August 28th, 2025, suspending his trainer's license and noticing a hearing for revocation of such license. On August 26, 2025, the commission had denied Rawlings' application to renew his harness driver's license. The notice of summary suspension and joint hearing also included notices for hearings on 2 harness driving disciplinary matters for which Rawlings had requested hearings, each for violations of the commission's rules regulating a driver's use of a whip. The joint hearing was conducted on December 12, 2025. At the hearing, Rawlings withdrew his request to challenge the whipping rule driving violations, and staff finalized those penalties. The remaining issue from the joint hearing was whether Rawlings' trainer's license should be revoked. The hearing officer issued a report dated February 27, 2026, recommending that Rawlings' trainer's license not be revoked. The summary suspension of Rawlings' trainer license remains place pending a commission's final decision. The commission considered this matter at a hearing conducted pursuant to the judicial or quasi-judicial proceedings exemption of Public Officers Law, Section 108.1.
Mr. Williams, will you announce the determination of the commission?
The commission determined 6-0 to modify, accept the hearing officer, but modify the recommendations. I think some of your other fellow commissioners.
Would like
I'd
to
say
comment
so.
on that, Commissioner Mack.
The concern here, of course, is with the animal. The horse was whipped 7 times within a 365-day period. Mr. Rawlings has 47 such violations during the period of his career in various jurisdictions. The concern, of course, is that the care of a horse and the treatment of a horse is fundamental to the responsibility of this commission. We allow racing in New York. People enjoy it. We allow racing in New York. It provides income and jobs for a lot of people. And we provide income in New York because it provides revenue to the state. But with that enjoyment comes the responsibility of the trainer, the driver, and all those associated with horse racing to put the interest of the horse first. Now, the hearing examiner indicated that there is no history of where whipping itself has been the basis of a suspension or revocation of a license. That is correct. But I think he erred in finding that it was not sufficient for a suspension, because the whipping of a horse, whether it be 7 or 47 times, is evidence of his character and fitness as a licensee to be a part of this industry. Whipping the horse is evidence that he did not put the interest of the horse first. It's also evidence that he paid no attention and was willing to violate the rules of this commission, which strictly enforces whipping. And the reason for that is because it's now understood that one cannot talk to the horse after the race and ask him how it felt. Does it hurt? All we can really do is regulate the behavior of the driver. And we have, by rule, strict regulations on the driver. And he violated those rules 47 times, twice within a few days in August of last year. Now, he said he caused no harm to the horse. Well, that's his judgment. The rules are there to protect against harm and not rely upon the judgment of a licensee. He says that he saw no welts at any times. He's never caused welts. Well, again, that's not the standard. The standard is not to violate the rules and regulations of the industry, which this commission sets. Now, the third department, the Court of Appeals in New York State, has said that to maintain a license, the participation of the licensee must be consistent with the public interest, convenience, or necessity, and the best interest of racing. It is not in the best interest of racing to be flagrant in your violation of the rules. 1, because it shows contempt for the horse, and 2, because it's unfair to other drivers. It's unfair to other participants who comply with the rules. Mr. Rowley said he did this to encourage the horse. Well, encouraging the horse at the stake, at the risk and willingness of violating the rules and the risk of harming the horse is not something that this industry and this commission can concede to. And it's not his decision as to what encouraging the horse is or isn't. It's his requirement to comply with the rules and regulations of the commission. So I think the hearing examiner, who provided an excellent report and did an excellent job in outlining the case there, I think he erred in his judgment that this commission lacks the authority to do something about it. I think it's our role to do something about it. And I think that suspending his license is necessary here. And just to acknowledge that I understand that there is a pathway back for Mr. Rollins. He will have a right to reapply for a license. And in doing so, I think it would help him to show his remorse and his concern for what happened here, and perhaps engage in some remediation and educate himself on the importance of following the rules and put the horse's care and treatment as a priority. And so I think Mr. Rollins can do himself well by looking forward on this and finding ways to remediate his behavior if he hopes to reapply at some point in time, have a license renewed.
Thank you, Commissioner. Commissioner Machete.
As I had indicated, to me, his improper conduct as a driver reflects on his character and fitness as a trainer. Trainers are obligated to follow the rules and regulations. They're responsible for the health, fitness, and well-being of the horses they train. You know, and trainers and drivers are involved in race strategy, right, all the time, including driving and encouraging the horse forward with the proper use of the whip. The whip is used there. We allow it to be used, but it has to be done properly. His attitude as a driver regarding the use of the whip is totally inconsistent with the attitude a trainer should have. So I don't think you can make a distinction between the two licenses in situations like this, especially given the factual conduct here that was illuminated in the hearing officer's decision. So I think that while I understand some of the rationale of the hearing officer, I believe he was wrong, and that Mr. Rollins' license should be revoked as a trainer.
Thanks, Commissioner. Anybody else wish to comment? No. Thank you. Mr. Williams.
Next case is on September 30th, 2025, the Bureau of Licensing issued a notice of license revocation to Unique Starting Point LLC, doing business as Point Break Bar at 445 Hempstead Turnpike in West Hempstead. The notice informed Unique Starting Point that their license was revoked for engaging in conduct that constitutes a fraud, deceit, misrepresentation, or conduct prejudicial to the public's confidence in the state lottery, violations of commission regulations, lack of experience, character, and general fitness as a lottery sales agent, and violation of the terms of the New York Lottery Retailer License Agreement. Specifically, the notice stated that the action was being taken because the owner of Unique Starting Point was arrested and charged with a Class A misdemeanor possession of a gambling device. Unique Starting Point requested a hearing, which was conducted on January 21st, 2026. The hearing officer submitted a report to the commission secretary dated March 11th, 2026, recommending that the license be revoked. The commission considered this matter at a meeting conducted pursuant to the judicial or quasi-judicial proceedings exemption of New York Public Officers Law, Section 108.1.
The commission duly deliberated and considered this matter and determined upon a 6-0 vote to sustain the hearing officer report and recommendations, accepting the exceptions of to the hearing officer report filed by the commission's counsel, which reflected some minor corrections. Mr. Williams.
On September 15th, 2025, the Bureau of Licensing issued a notice of license revocation to BTB Pizza Incorporated, doing business as BTB Wood Fired Bar and Grill in the mall at the Grease Ridge Center in Greece. The notice informed BTB Pizza that their license was revoked for failing to pay New York tax obligations. BTB Pizza requested a hearing, which was conducted on February 6, 2026. The hearing officer submitted a report to the commission secretary dated March 31st, 2026, recommending that the license be revoked. The commission considered this matter at a meeting conducted pursuant to the judicial or quasi-judicial proceedings exemption of New York Public Officers Law, Section 108.1.
The commission duly deliberated and considered this matter and determined upon a 6-0 vote to sustain the hearing officer report and recommendation to accept that accepts the exceptions of the hearing officer's report filed by commission counsel in which minor corrections to the record were made. Mr. Williams.
On October 15th, 2025, the Bureau of Licensing issued a notice of license revocation to McGregg Pub Inc., doing business as Sean Patrick Pub at 1762 Broadway in Hewlett. The notice informed McGregg Pub that their license was revoked for engaging in conduct that constitutes a fraud, deceit, misrepresentation, or conduct prejudicial to the public confidence in the state lottery, violations of commission regulations, lack of experience, character, and general fitness as a lottery sales agent, and violation of the terms of the New York State Lottery Retailer License Agreement. The notice also stated that the action was taken because the owner of McGregg Pub was arrested and charged with a Class A misdemeanor of possession of a gambling device. McGregg Pub requested a hearing. The hearing officer submitted a report to the commission's secretary dated April 20th, 2026, recommending that the license be revoked. The commission considered this matter at a meeting conducted pursuant to the judicial or quasi-judicial meetings exemption of New York Public Officers Law, Section 108.1.
The commission duly deliberated, considered this matter, and determined upon a 6-0 vote to sustain the hearing officer's report and recommendation, except to the exceptions to the hearing officer's report filed by commission counsel as to minor corrections in the record. Mr. Williams.
Harness Racing owner-trainer Edgar Clark was issued a notice of violation on October 15th, 2025, revoking his owner-trainer license on 4 regulatory grounds, finding Clark had applied an irritant to a light switch in a barn at Tioga Downs with the intent to harm another. A 5th regulatory ground was later added. In revoking his license, staff concluded that Clark's experience, character, or general fitness in harness racing was inconsistent with the public interest, convenience, or necessity, or with the best interests of racing in New York State. Clark requested a hearing, which was conducted on February 5th, 2026. The hearing officer issued a report dated April 24th, 2026, recommending that Clark's licenses be revoked for violation of Commission Rule 4119.9A as authorized by Racing Parimutuel Wagering and Breeding Law, Section 309(2), and that Clark be expelled from the track as an undesirable person by reason of disorderly conduct within the meaning of Commission Rule 4119.8D. The Commission considered this matter at a meeting conducted pursuant to the judicial or quasi-judicial meetings exemption of New York Public Officers Law, Section 108.1.
Commission duly deliberated and considered this matter and determined by a 6-0 vote to sustain the hearing officer's report and recommendations. That does it for our adjudications. Is there any old or new business to come before the commission today? Hearing none, I would just like to make a couple of comments, particularly echoing the comments of Mr. Williams. The Resort World opened in record time after we gave them the license, and in a way that most of us thought couldn't be occurred. Now, while it was very, and this is important for both Resorts World, but more importantly for the state of New York in terms of the gambling, the taxes that are going to be received. Resort World did a yeoman's job in opening up, but so did the people in our commission, our employees who were up there working seasonally to get the Resort World open. And I want to recognize Tom Fataruso, Scott McClear, and Shaki Schultz, who each have spent days on site working through the regulatory requirements for it being necessary for the opening. They did tremendous work. Also, Christy Phillips of the Bureau of Licensing, Nicole Kensor from the Bureau of Finance and Administration, Ralph Scusiano and Christine Carpenter from the Bureau of Risk Management, Steve Lowenstein and Chris McManus from the Executive Office, all of whom did incredible work, and people of New York are most grateful for their work on behalf of both the Commission and the state. I I did want to say that there is obviously a potential dispute at NYRA that might affect Belmont, and the IBEW. I have been in touch with the parties to urge them to resolve their dispute. Say that I, as commission chairman, have a role in this, and that we closely monitoring that dispute. And while it is not my intention, nor is the commission's intention, to take sides in the matter, it is our intention to make sure that the public interest is protected and that the racing goes on as scheduled in early June. And as I said, we have a role, and we're playing that role in that regard. Finally, I just want to say that today we met with potential monitors at Resorts World. I'm sorry, at Empire's, at Hard Rock. I'm sorry, Hard Rock, and we had a good meeting. We have a lot to discuss, as we have done with all three monitors or potential monitors. We have given them the what we consider the important roles in preserving their promises to the communities and to operate in a lawful manner, and particularly in their promises for diversity in their hiring practices. When we all voted to give these licenses, we noted that our real concern here is to make sure that the benefits of the casino go to the people in the communities in which they are addressed. And I want to know that I'm sure that that's going to happen with these monitors. We will be closely dealing with the monitors. We have a series of follow-up questions and meetings, but I think the people of New York can be satisfied that these things are, that we will in fact have a full compliance. Finally, we look forward to a really excellent Belmont in June, where we have one of our first female trainers is going to be with her horse, and again, I will try and not root for any horse. That's not my job, but I do. But a New York trainer and roots in Saratoga, one can hardly not be rooting for her. Do I have a motion to adjourn?
So moved.
Hearing some, all those in favor? Thank you very much.
So I guess any negotiation.
I have tonight.